I've seen it before.
Thank you for joining us. My name is Anina, Dalsin. I'm the president with Heidi Coach Hermelin. Next year, we're co-presidents of the solo section who is sponsoring this today. And it's my pleasure to introduce our two speakers, Terry Leoni and Lee Montes. Terry is the liaison between our solo section and the Bar Association. She's a great help to our section, so thank you for that. And I noticed that their bios are there if you want to learn more about them. But Terry's an employment and labor lawyer. She worked before as a district attorney and moved to her own practice about 6 or 7 years ago. Is that about right? Yeah. And focuses mostly on labor employment issues in all aspects and representing plaintiff employees, right?
Generally employees, yes.
Okay. And Louis had his own business for many years before going to law school. So this is sort of a second career for you, right, Louis?
Yes, it is.
And he's a business lawyer, and his business acumen really lends itself to being a great advocate for his clients, working a lot on transactional and litigation matters.
Mostly transactional, but we stumbled into litigation on occasion.
Okay. And I'd be remiss to two things. Please come to our section's Christmas party. We're very excited about this. It's on Tuesday, the 6th of December. It's at a restaurant in Concord called Puesto, which is in the Veranda Shopping Center. It's going to be awesome food, drinks, merriment. So please come and bring a guest if you like. But that's on the 6th of December. You can RSVP on the website for the CCCBA. Okay, without further ado, I'm going to say it. Please take it over.
Thanks, Anina, and thanks to Louis. I volunteered him for this, so I'm so glad that he said yes and was able to do it, even though he is missing a little bit of his vacation. So thank you. And thanks to the solo section. So it's a nice small group today. I guess my first goal is that no one falls asleep. Yeah, that's true. It is freezing. The second goal is that, just to give you a little bit of an idea about smart growth and whether growth is more people in your office, more money, more time, thinking about that. I really hope that I don't overwhelm or scare you, or you're like, oh shit, I'm doing it all wrong. We can always fix things. Most of what I'm telling you is because it's mistakes that I've made even as a labor attorney and sort of my trial and error. And then, for questions, feel free, especially because it's a small group, if we want to just, ask questions now, that's fine, or if you want to wait till the end of my program or everything, I don't have a preference.
Oh, and materials are available if you haven't downloaded them, but these presentations are available online, so please check them out.
And just a little bit more about me. I do some employment advice and counsel for small businesses, especially compliance issues. I love going in and seeing, hey, how can we get you up to speed like what we're talking about today? But it's more all things employee. Easy way to think about this, my last name means lion in Italian, labor law lioness. That's a good way to remember it. Okay, so one of the biggest, sorry, I am really cold. I think one of the biggest issues, and what I get so many questions about, especially for solo and small firms, and one of the most confusing issues maybe lately is independent contractors versus employees. Who should I bring on? Should I hire? And this is just, I think, such a huge issue. And you want to maintain compliance, and you want to maintain, especially as a lawyer, don't do the do as I say, not as I do type thing, which is what I've done in the past. But just to note, in California, there's generally a presumption that workers are employees. So you always want to come from that point of view. Is this person really an employee, or are they actually an independent contractor? As an employee, of course, you have to do, there's the workers entitled to overtime, meal and rest breaks, there's pay stub requirements, sick leave, a bunch of other rights, and an independent contractor doesn't have that. They are truly independent from your business. And I guess, actually, let me go back a little bit. So when Louis and I were prepping for this, he asked me a question like, what about my administrative assistant? And I think a lot of people think about that when hiring, can I cut corners, or should I hire an independent contractor, or should I hire an employee? And what comes across, not necessarily my desk, but a lot of questions I get are, you know, I just need a part-time assistant, maybe 15, 20 hours a week. They're gonna work remote now, but they're gonna have my email, you know, there's some control, but they're not necessarily coming into the office. And we've agreed that they're an independent contractor. That's fine, right? We've signed an agreement. Probably not. And of course, you know, I've learned this the hard way as well, but in 2019, I'm sure everyone has heard about this, AB 5, really changing the landscape for independent contractors. It's not just that I want to be an independent contractor or you do, we've come to an agreement. The law has been codified in the Labor Code 2775, and they changed what's called the old Borello test to the ABC test. And of course, this is such a huge issue. You hear about it with the gig workers. I think Uber just had a $100 million settlement with New Jersey. It's happening every day, but it happens on a small scale too. I have people coming saying, hey, I think I was misclassified as an independent contractor for the past 4 years. That's how far I can reach back and say, how much overtime do you need? How much meal and rest break? Like, okay, do I get to remodel my kitchen? I mean, it can be very expensive. So in order to make the proper determination, think about the ABC test. And they have to meet all three. And if they, a worker's only an independent contractor if they meet all three of these. And again, it's really presumed that they are an employee. So autonomy. Are they really independent from supervision? Are they free from the control and direction from the hirer or the employer? Are you saying, hey, here's a project in 2 weeks and then, you know, get back to me? Or is this daily? Are you, you know, like my assistant will be meeting every morning at 9. I'm gonna look at her work. We interact on a daily basis. Probably for an administrative assistant, they're not going to be free from control and really have autonomy. So you can probably say no to the A. B, business. Think about it is this the scope of business that a worker generally performs? It's the usual course and scope of the person's business. So if you're hiring an administrative assistant, a legal assistant, a paralegal, those are generally within the normal scope of a law firm. Now, thinking about a CPA, do I need to make a CPA my employee? Well, that's not really within the course and scope of a law firm. Or someone doing marketing. You know, that is not necessarily within the course and scope of a law firm. So you could generally say, yeah, I think I could think of that person as an independent contractor. They probably wouldn't check that box. But again, an assistant or a receptionist or a paralegal, a legal assistant, that is really within the course and scope of what we think of as part of a law firm. And then the third thing is custom or customary. Is the worker customarily engaged in an independently established trade or occupation or business? It's, you know, kind of thinking about what has been the normal past practice for this. Administrative assistants generally are not one to be independent contractors. They are controlled. A legal assistant, same type of thing. A paralegal. I would say, you know, if someone comes to you and says, hey, this is my business, I'm offering my services to Terry, me, to Louie. That's a little bit different. But if you're thinking, what? We're both agreeing that they're an independent contractor. That doesn't matter. What the law has also looked at or carved out examples of what is sort of customary and customary to be an independent contractor. Real estate agents, insurance agents, fishermen, administrative assistants, and, you know, paralegals, things like that are not really, you know, carved out as an exception. So the rule here, I would say, you know, thinking about the hypothetical, probably not. I mean, the law firm should be worried if they hire that person. Yes.
So if you fit into one of the exceptions that you're talking about, fishermen,
attorneys in it.
Well, we're going to talk about that next.
Does that mean that you don't need to go through the analysis? Like you're automatically safe harbored, or you
Not
still
necessarily, because if you, let's say you have more control over the CPA, or you want, you know, sort of this C FO within your firm and you're controlling the work. They come in, they don't have a remote business, you're supervising them, you know, it's their business card, your email. So it's not, there can be exceptions, but if there's more of that control, if they are more like an employee, then they, just because there is the exception, doesn't mean that they are not necessarily an independent contractor. And that actually comes to lawyers. So they are specifically excluded from Labor Code 2775, the ABC test. And I have gotten in, let me say, friendly arguments with people about this. It does not mean that they are automatically independent contractors. They now have it's the old Borello test. So just because you have a law degree doesn't mean that you can just say, great, I don't have to hire any associates as employees. They're all independent contractors. Wrong. You just use a different test. So the test is 11 factors. And really what it looks at, it's pretty similar in terms of control. Are you supervising them? You know, do they come into the office? Is the hiring entity required to give advance notice? You know, is there, again, a lot of it is about supervision and control. And how I think of this is, you know, I've had firms hire me or my firm to do, you know, like a general counsel has hired me for a business who has an NLRB complaint against them. And that attorney doesn't supervise me at all. I handle all the pleadings, I deal with opposing counsel, my name is on all the documents. That is truly maybe an of counsel or independent counsel relationship. But I've probably, you know, I'm sure we've all done this wrong before, or, you know, learning by trial and error. You have someone that you are supervising. Hey, here's this project. You need to do the demand letter. They get it back to you. You mark it up, give it back to them. Your name, you know, they have maybe your email, or your name is on the top of a pleading and theirs is on the bottom. That does not sound to me like an independent contract relationship. And again, if you're really controlling and supervising the nature of their work, or they're really like, you know, a junior associate, they're probably they're probably an employee. So that's really important to think about, you know, are you misclassifying your employees? Because it can be very, very costly. You're gonna get, you know, potentially overtime, meal and rest break violations. You haven't provided them a sick time. There's, you know, you have to have work comp. There's a lot that goes into it. There are certain requirements that you have to have on pay stubs. And each one of those, a plaintiff's lawyer is going, gee. You know, I've handled a lot of them. And once you get that hurdle that you've misclassified them, it can be very costly. And I don't say this, of course, to scare you, like, I'm never gonna hire. Once you get to that hiring your first employee and doing it right, then it gets easier and easier. It's just having all of the knowledge to know that what you have to, you know, that you don't want to misclassify people. And if you have to get rid of them, and this is how they come to my desk, then they say, maybe I should have been an employee. And if you can reach back 3 or potentially 4 years for all of the liability. So just think about that and some of these other issues in terms of the wage and hour concerns, excuse me, when there's a misclassification case. So that leads me to hiring. So if you want to grow, you know, have more time, go to Mexico, which I still haven't been able to do, and you know, you don't want to mess with the independent contractor situation, then you should hire right. And really think about, you know, an offer letter. You can get the template from Google, which is my best search engine, or you can go to Cal Chamber, or, you know, what I go to other labor and employment attorneys, you know, keep someone on retainer to have the right information in an offer letter. You want to have, you know, the business location. If they're remote, are they going to be paid? If they're remote, are they going to be paid to drive to the office? You want to have, you know, the hourly wage, if they're exempt, if they are salaried, if there's a bonus. So you really want to think about the formal offer letter, and also mention if they are at will, or if this is a contract. Of course, in at-will employment, they can be fired at any time for any reason, as long as it's not unlawful. So you don't want to just hire someone, kind of off the seat of your pants and say, it'll work out. There's a reason that we have all of these labor laws, because it hasn't worked out. So you want it to be formal and also comply with the law. And then, I threw this in, I don't know how relevant it is, but a few years ago in 2018, I guess that's probably more than a few years ago at this point, but California did a lot of making sure that people with convictions on their record really could work, especially if they were rehabilitated. So there's a lot of ban-the-box legislation, like, do you have a conviction? We're not hiring you at all. So be careful if you are hiring someone saying, I'm going to do a background check or a credit check, because, excuse me, you can only do that after a conditional offer. And then you can run a background check, and if you decide you don't want that person, then there's a lot of other procedural avenues that you have. And part of what makes me bring this up is because a few employers and other people have asked me about it lately, and it's come up in a few areas. But you need to be aware and stay on top of big issues that change all the time. This was a big issue in 2018 for applicants, 2019, it's the independent contractor, then we have a lot of the Me Too stuff. So something to think about. But also hiring, I'm sure everyone can see all this little tiny writing, right? Again, this is trial and error on my part, even as a labor and employment attorney, hiring people and sort of saying like, I'll figure it out later. It doesn't always work. So I have created a hiring checklist. A lot of it is off of this slide. You can go to Cal Chamber, you can get a subscription, they can assist you, but there are a lot of mandatory documents that have to be provided when you hire someone. So that's why I put that arrow. Anything in blue you have to provide to someone, including like sexual harassment, discrimination, policies, things like that. So once you hire one person and you have this checklist, it just gets easier and easier. And if you are a member of like Cal Chamber, then you have this information. They'll update you every year if you need to add something. So hiring right is essential. And a few years ago this year, there was a law that you have to keep all of the personnel files for 4 years. So not only your employees, but also applicants. So just keep all of that information, and that often relates to discrimination laws. Why are you not hiring someone? And then there is a new law coming up on January 1st of 2023, the Pay Transparency Act. So if you are an employer of 15 or more employees, you have to include a position's salary or hourly wage range on any internal or external and postings. So I say that because a lot of the labor laws are tied into how many employees you have. And again, this is tied into implicit or unknown bias, or maybe explicit bias, when we're not paying people what they should be paid, or pay equity. And that leads me to I call the 5 is the magic number. A lot of labor laws used to be only if you had 100 employees or 50. FMLA right now is only if you have 50 or more employees. That number for a lot of these things keeps creeping lower and lower. Like pay transparency for 15 or more employees is not really that many employees when you think about, do I calculate myself or receptionists, admin, and it gets lower and lower, and a lot of them, the threshold where they trigger leave laws or some other benefit is 5 employees. And there's you have to think too, kind of outside the box, who qualifies as an employee? Part-time people, full-time, If you have like seasonal employees, maybe if you have an independent contractor that isn't truly independent. And there's some controversy or, difference on whether an owner qualifies. I always err on the side of caution when I'm advising business clients that you do qualify as an employee. So if you have 4, let's say 2 part-time employees, 2 full-time associates, you make that 5th person. And then all of these things click, and that's sort of the trigger for these issues. I know that seems like a lot, so you're probably like, oh my God, I'm doing it all wrong, or I'm never hiring anyone, or I'm just gonna fold up my business right now. A lot of them are never gonna come to fruition. Like, are you really gonna require volunteer leave? It's for volunteer firefighters, there's like a civil service leave, but you have to be aware of certain things. And some things you probably already have as part of your business, like the smoking prohibition or child labor. But there's some things that you may not be aware of, like you need to make a lactation accommodation or jury duty leave, things like that. And, thinking about FMLA, where people are allowed to take time off for themselves or a spouse or, someone else who's close to them up to 12 weeks for, certain, if they qualify. That's 50 or more employees, but California has the equivalent, which is CFRA, and that's 5 or more employees, and they get to take time off and their job is saved. So being aware, once, do I want to hit that 5-person threshold? I don't. I don't want to have all that stuff kick in. So just, things to think about. And again, hopefully I haven't thoroughly scared you, but it's just things to be aware of. How much time do I have?
You're almost.
Okay. I'm probably talking too fast then. Okay, so now that everyone is thoroughly like, oh my God, what have I done? Or I'm not hiring. The totally easy, non-controversial thing, harassment, discrimination, and retaliation. So I don't think I need to go into great detail. We're all attorneys, I'm sure we've all learned about this, but a good refresher or just a few things, again, thinking about, do I have liability on my own? Because there's personal liability. When these cases arise, there can be liability against the business, and it's probably far broader than you have imagined. And even if there's not necessarily a valid claim, I always think about the reputation. If you have these issues, if you are sort of a toxic boss, which I can, I'll talk about, or, these in-house issues of harassment or discrimination, or even allegations of it, are you going to be like the next Jones Day, where there was, 7 or 9 women that came forward and called that law firm a frat house, the old boys club. It can be, we're a small community, especially here in Contra Costa. It can be really damaging to your reputation. So really think about these things. And I think thinking outside the box when it comes to this is important. So who is in a protected class? I would say probably almost everyone. So it's not just age, but it's race. Any of us over 40 are old, so that's a protected class.
Lucky I'm 39.
Next year, they're joining us.
Yeah. Then you get to join the club. That's always what I have my date of birth in the intake. Everyone has to fill that out, so I know, is there a trigger? Are you being terminated because you are old at 41? So, age, race, ethnicity, veteran status, LGBTQ, are you transitioning? Religion as well, being, Catholic, Jewish, Muslim, I'm trying to think of some others. Medical issues, do you have anxiety? I think most attorneys probably do. We're high functioning. Have you had a child? Then you are a protected class because having a child means you've had a disability. So things like that, it is not just sort of the stereotypical, I'm a woman and I'm in a protected class or a different race. I think almost probably anyone here qualifies. But these are the cases that come across my desk like day in and day out that have the biggest misunderstandings, I'll say. So thinking about harassment, and again, the tipping point, I'm sure we all know, is it a protected class? Although we just talked about it's somewhat easy to get, to be a protected class. But for harassment, is someone treating you, or an employer or an employee treating you badly because of your protected class? Is someone treating me badly because I'm a woman? And often that's the hostile work environment, but not the hostile work environment that comes across my desk on a daily basis, where people say, oh, my boss is hostile, or I've been bullied, or I call it the toxic boss syndrome, or the asshole boss syndrome, really. That you have an asshole boss, but they are toxic or bullying or mean to everyone, so it's not just you. So people don't understand what that, the hostile part of hostile work environment means, but again, it's, someone treating you badly because of the protected class, but you can see that if people are being treated badly and it's unchecked, a less scrupulous attorney might take that case up and you still have to defend it, or your reputation could get out there. Because those issues within the workplace just really affect people emotionally, physically. And discrimination is treating someone differently because of their protected class. So people have either, the appearance of, or there's truly discrimination because of their protected class. They're not hired, they're not promoted, they're not given a wage increase, or they're terminated because of their protected class. Then again, a lot of cases actually arise out of the retaliation part. It's a little more nuanced, but it's really punishing an employee or an applicant for a job for their legally protected complaint. So there's, some nuances, whether it's what's legally protected, but for instance, if someone complains about harassment or discrimination, even if it's unfounded, you can't then retaliate against them and say, thanks for bringing up the complaint, Julia, but I'm going to fire you for that. Can't do that. And I think that's where a lot of employers make that mistake. You're a squeaky wheel. We're just going to get rid of you. Again, even if there's no basis for it, they have the right to do that. So kind of think outside the box, if you're noticing problems in your firm, or, just issues, or if there's complaints, thinking about how this can be avoided and handled. And again, I know we're going really fast through all this stuff. And thinking outside the box here are other considerations. No one ever wants to get a text message like that at work. I've had a lot of cases like that. But things don't just happen at the office, the harassment or discrimination. Text messages, emails, phone calls, I've had social media where the connection is at work, but they're sending them dirty pictures, things like that. Flirting is a big one. What you may see as walking by and winking at someone's office, or hey cutie, or oh you look great today, isn't just flirting. And I used to have sort of an equal opportunist slide, I should have put it in, where it was Democrats and Republicans, older men always hugging on young interns and women. So flirting is not always flirting, and so that's something to be aware of as well. The same with joking. Joking isn't always joking, and what you're comfortable with doesn't mean someone else is comfortable with it. So, are you going to be, it's probably what we tell all of our clients, if you have to talk to your mother about this, or get up on the stand and talk about what you've said, or what your employees have said, or the UPS person that comes through, are you going to be okay with how that comes across? Maybe not. And, the responding to complaints, that's something that always has to happen. And, we talked about the toxic boss syndrome. So if it's not retaliatory, you want to make sure they are also firing correctly. Don't do it in retaliation for making a complaint or, obviously because they are in a protected class, things of that nature. But if you like hiring, I always suggest having a checklist. And it can be as simple as, have I gotten back the documents or confidential documents or our property from them, or do we want to give them their property? Or you have to make sure that you give them their last paycheck. So you want to make sure you go through everything that's required when someone is terminated and do everything correctly. There are a lot of penalties, especially if you don't provide the last paycheck. But one of the best pieces of advice and how I've talked to my business clients through terminating someone is being open and honest, but having sympathy and empathy. More often than not, my plaintiffs' clients who call me, it's because they were terminated and they felt, I didn't have any notice, or I just got this email. I had a Meta or Facebook person call me, and it was like, we just get an email and no one will tell me why. I had another gal call me 2 days ago and it said, I've worked at this company for 17 years and I got an email and I'm being terminated. And she's pissed, and rightfully so. So having a little empathy and understanding for the person that you're letting go goes a long way. They're much less likely to have that horrible emotional reaction and want sort of vengeance against the employer or the person that is firing them. If you can explain what's going on and be open and honest. I had a client who said, we're getting rid of your position, and then hired a woman who was 30 years younger than the other gal. So that's not a good thing. And it looked like age discrimination. But just have some understanding, talk to them, see if you have it in your finances to offer some sort of severance agreement, and try to do things not like Elon Musk maybe. But that's thinking, kind of about the replacement. I think that goes a long way for helping people move on, keeping, some semblance of their respect for them. And it also can, I always think of your reputation, and you don't want to be the horrible boss in the legal community as well. So not only lawyers talk, but maybe administrative assistants or paralegals. So thinking about those kinds of things.
Terry, I have a question for you. Sort of moving toward the termination phase. Is what about disciplinary action? What about documenting things? Like, everything's going great until it's not. And then when you want to terminate someone, you've got nothing in their file to show that they've been a poor performer because you don't want to seem heavy-handed.
Sure. And I think, even though most places are at will, if they're not a public employee or like a C-suite where you have these umbrella clauses, and at will you can be terminated at any time or leave at any time, I think it's still a good idea to have some sort of progressive discipline or notice to the employee. So again, it doesn't come as a surprise, or it doesn't seem like you're targeting them for their age. And it's a notice to them that they should be changing their behavior. And it's always better if, for my business clients, if they come to me and say, hey, I just got this EEOC claim or DFEH claim that they were unlawfully terminated. I had one recently, and it was written warning after written warning after written warning for different things. And then they got to, this is your second warning, and then it was the final warning. So that's far better to document that way, even if it's an oral counseling, like, hey, Louie and I had this meeting yesterday, he has come in late every single day for the past 2 weeks, just letting you know.
That's me.
Yeah.
You're fired.
And then putting it in their file, you know, except for the most egregious things, like, okay, I caught you doing coke in the bathroom or something, but it is good if there's performance issues and that's the reason you're going to get rid of them. It's really good to document it. Luckily, I am on the last slide. So, labor laws change. Sorry, I am so cold.
It is amazing. My hands are freezing.
So they change every year. There's always big changes that start in January, and there's often changes in July as well for the sort of late legislature, and they can be big, like 85. But there's one, you know, and I included a handout, well, not, I guess it's not a handout, it's some virtual information about some of the bigger labor law issues and changes that are coming in. For instance, for off-duty, this is a big one. Off-duty, I say off-duty, but if you're not working and you're not on premises and you are using marijuana, you can no longer be disciplined up to and including termination. You know, the Pay Transparency Act for 15, people calling me, 15 or more employees. You know, some of the other new ones that might impact. Oh, COVID law is still here to stay, so people can pay or take supplemental sick leave. CFRA, which again is for 5 or more employees, where you are able to take leave. It's generally up to 12 weeks of leave, and it can be intermittent. And the federal leave is much more strict. California now allows it for grandparents, spouses, LGBTQ, they've made a big expansion. So there's little and big things that impact the labor laws and can be, you know, again, as low as like the 5 is the magic number. So I included some of that. I often say, you know, if you're a member of Cal Chamber or subscribe to like Safarth and Shaw, they're a big employment council, or Littler Mendelson, or just Google, you know, every December or January to get the new laws. Certainly, I'm sort of putting myself and other attorneys out of business, but you know, that's the best way to know the new laws. That's it.
Any questions from people? I have a question.
Yeah.
But I don't want to hog all the question time.
No, feel free.
So what would be your advice to someone who has misclassified either an independent contractor or someone who is exempt and they're not supposed to be exempt? Sort of, oopsie, now I want to do it right. What's the best way to do that without bringing a claim to yourself?
Yeah, and I mean, obviously that's happened a fair amount. I think you just go back. If the person hasn't raised the claim, you can just go back to them and say, you know what, I think you don't have to bring it up to them. You can say, you know, moving a firm in a different direction, or I'd really like to have, you know, more, I don't know if you want to say control, or let's talk about making you an employee. And, you know, we're talking to them about what that means. Or if they think there's issues that have happened before, sometimes you can say, here's a severance agreement. I wouldn't recommend that because they're going to, not a severance agreement, you know, like a waiver of any past claims. Anyone who's working in a law office is going to be like, why are they giving that to me? So I don't know if I would necessarily say that right off the bat, but we have done that, you know, before, where it's sort of gone down the road where it's, hey, I want to make you an employee. You've done such a great job here. I want you to be more a part of the team. You know, let's talk about what that means.
And then maybe give them a little bump or a little bonus or pay them something, right?
You can. It's going to be more expensive to make them an employee. You have to pay work comp. You have to pay, I have a, you know, payroll. It's not altogether that expensive if you use something like Gusto, but there's still a monthly fee. You know, you have to provide sick time. It's 3 days a year, or if they're there for more than a year, it's basically 6 days. Or if you want to say, hey, I'll give you some personal time off too. So, you know, you can say, I'll keep your pay the same rate. It's just if you want to keep them too. And then for the exempt, you know, that's a little bit harder. To say you're exempt, I guess you know, to say now, hey, we're changing the scope of the business. I realized before you were an exempt employee, so you didn't have to have overtime or meal and rest breaks. We didn't have to necessarily give you X, Y, and Z. But we're changing the structure of the business or the firm, and here's the new package that you have. You're no longer a salaried employee, you're hourly. Here's the equivalent hourly rate, but also you need to be, and yay, you get overtime, And then giving them kind of the new policies on what overtime is, when they get their meal and rest breaks, things like that. It may be acute to them, but then you can kind of deal with it as it comes up. Like, hey, I also think, sorry, to back up, you should know the liability as well. So talk to someone about, hey, I've had this person for 6 months. I know that they've been misclassified. What do you think my liability is? And then, they can break it down. My associate is really good at that. I don't love it. And say, so here's the, what you should offer them to waive all prior claims. But you want to know your liability beforehand too.
Does that waiver protect you from any government sanction or fine or liability?
No, not necessarily. Like the DFEH or the Labor Commissioner or DLSE, they could potentially come after you. But if it's for something minor, it's unlikely. If you are consistently misclassifying employees, it happens a lot in the construction industry. So I also have kind of a smaller criminal part of my practice, and I've represented, sort of the white collar crimes like work comp fraud, insurance fraud. That's when like the DA or other entities come after you. There's certainly penalties that can happen. And that you're assessed, and they can be a lot, 10,000 here, 20,000 here, but it's much less likely, especially if you're treating this person, kindly. You want to, if you end up having to explain the situation, I'm not sure they necessarily, figure that out, or like the IRS is not going to tell them, or the FT, the Franchise Tax Board. It's bigger fish that they look at who are intentionally misclassifying. But there's, the lawyerly answer is it depends.
Thank you.
Great, everyone's still awake. There's not enough people here.
So why don't you and I
Yeah.
just switch, and let's have a 5-minute break so that we all, including
Warm up.
myself, can warm up. And 5 minutes and we'll get at it. We've got a lot to cover, and we'll try and cover it.
All my stuff are down there. No, that's in the house because there's families all staying in the house. We've got lots of people in the house that work out really well. My dog is right. Yeah.
Do you have any employees?
But I have
It's just,
like most friends up there. It's like I'm really my laptop and my facilities. No, we got a restaurant.
yeah, so I'm not.
We did have one year, like, it's not hard to get through either. I thought you had pre-order. The first week I was employees, giving like, I looked at like pre-order.
I was working in a contractor,
But
and then we decided to move into employee because I don't have
So the year that
business.
my dad came, we had lots of people who did American
But,
Thanksgiving.
yeah,
This year.
that was pretty good. I
And
was
those
there
are-
for fun.
Yeah.
Pete and Mike are.
It's not Thanksgiving.
Well, the Americans, they celebrate Canadian Thanksgiving and in my community, we serve a lot of expats.
Oh, I'm not sure, so I can show you something kind of fun. if you want. Let's see if I can pull it up.
When you meet friend next time, maybe I'll just take it off that.
Yeah.
Oh, Pranita, you need to sign it.
Oh, okay. Heidi that.
She just went to the restroom.
Okay. Sixth time on 3, oh, so she's just gonna leave at 3, okay.
Get some hot tea.
Water, just water.
Hello.
So you're leaving at 3?
What's your name?
Oh, so what's your name?
Natasha, I'm Anina.
Oh, okay.
Nice to meet you. What's your area of practice?
Appreciate it.
Oh, great. Where do you work?
I work,
No, I thought it was.
but my office
Just
is
estimating.
Oh, okay, okay.
Thank
And so what brings you all the way to this part of the day?
I actually live here.
Oh, do you? Okay,
Yeah,
okay, cool. And what types of immigration cases do you handle?
So, I moved
Oh,
to
there we go.
asylum, and then, other situations that kind of related to that, so, there's a UT visa.
Okay.
And then, legal permanent residency.
So not labor-based immigration?
Oh, so yeah, I do the trafficking,
Okay,
so, some of that does include.
okay.
So you're the first person in the public to see it.
What about you?
I am a business lawyer, so my clients are
Oh, yes, it's like
I serve as outside counsel, like general counsel, so I do all manner of kind of business transactional stuff, I do some employment stuff, I do real estate leasing,
So what are you doing?
commercial leasing.
We're not sure.
Kind of what I'm busiest with right now is leasing, tenant side, but everything else seems to be slowing down, but that's really hot still. There's a lot of like, South San Francisco, there's a lot of outside leasing right now. Yeah, and I swear, it's actually from Lauren.
Is it?
Like 200 pages long.
Oh,
Yeah,
okay.
yeah, usually, there'll be
It comes by all the
companies,
time.
my typical client behavior is usually a company, an agent
But it's
company,
fun.
established a
We're-
US presence.
He's editing right now.
And so they don't have any counsel
should-
here, and so then I
Gotcha.
get their employment work, and
Should be-
I'm very happy, because that's what I prefer to be doing.
So are you
Or
also
other than
gonna
just business transactions, so I get
Should
them
be-
released, but then they
Yeah.
like me to hang on to them, good stuff that I like to do, yeah.
So,
Yeah,
are you
should be pretty fun.
I live in Montes, I work in
Oh, yeah.
Yeah.
It's a romantic comedy.
So when did you
I
Because you
Great
always
question.
you always want to see it, right?
Not always.
I know, I like how the
I know, so the lease date is
building for
getting
about
pushed
7 years, I
back.
was in.
Always.
The editor that he
And then
hired,
during the pandemic, I let that
yeah,
go.
wasn't
And
great.
then afterwards came back.
And so he's kind of
Advice?
Yeah.
It's hard to explain, like, what is
That's
it
so
about it?
funny. It's so funny because it's like
That's
a city building.
Yes, I'm looking at a different outlook, I mean, I was getting a little bit of like.
Yeah.
So how, no, halfway downstairs.
Oh,
I should
there we
just
go.
get
Part
one
of
of
the
these.
You probably only go up there once in a while. You're like,
Yeah, exactly, to print things.
Yeah, exactly.
Send it to
Take them when you
printer.
can.
Exactly. Right, nice talking to you.
All right. Hi, Anita. We'll,
Yeah.
after the
Yeah.
presentation. All right. Yeah, there's enough people here. We can get started.
Plenty, let's do it.
Yeah. Okay, so the first caveat is I hate slideshows. I usually give the handouts, but we'll make this work. And so my promise to you is that after we're done speaking here, or I'm done presenting, you'll have a very rough outline of what you need to do if you want to either remain, if you are a solo, or create one of the entities for your business. For attorneys, at least, I'm going to say small attorneys, under 5 attorney firms. I find it peculiar about the laws that affect us when we're creating entities and running our business, specifically the Business Suppression Code and our state bar rules regarding the liability that we incur from doing our business, which is a little bit more oppressive for us because we don't get as big a shield as normal businesses from liability from forming these entities. Nonetheless, you'll have a guide as to where you can go. In the handouts that are available online, I have an article that I have adopted from a practitioner who is much more versed in this. He and I did a presentation in San Diego about 4 years ago. Nonetheless, his outline of the considerations that you want to take as you're considering doing a partnership, a professional corporation, is really good and thorough. Of course, if you have any questions, you're welcome to reach out to me by email, and I welcome questions as we're going through the presentation. The way that this presentation is sort of designed is that you mentioned it about the growing a firm, or whether it's, what she said, more hours, more money, whatever.
More time, more
time.
Mexico.
Well, actually, as you grow, although we don't do it very well, as you grow your business, we should have a little bit more time to be able to go and spend more time away from the practice. You know, there's people like me who are workaholics who love our practice, but I still like to get away and go do other things. So we're going to talk about a little bit about marketing, because it's not really included here, but I use it for, I think for attorneys at our level, and I'm not talking big law or medium law or even small law, I'm talking about under 5 attorneys or thereabouts, is marketing is important for us, and we can leverage our entities in the way that we run our business to market. Obviously, the risk assessment that we go through it. The guide will help us attorneys. I've found in having attorney clients in creating entities is we're very hands-on and want to sort of do it yourself. And that's perfectly fine, and this will get you through there. There's even some examples that the state bar, example forms that the state bar requires when we form any type of entity, including partnerships. All right, so let's get started. The first thing we're talking about is the options that we have as attorneys for for how we manage and govern our practices. One of the big issues that you want to look at as you're looking at where you want to go with your practice is the strategy of where you want to take your business. Some of us are very happy to remain solos with some ancillary staff, and others of us want to get to the 5, we'll keep it under the 5 lawyer limit. Yes, wherever you want to go. There's some of us that want to go higher than that. I think one of the most important parts of where we're going with this is to have a clear understanding of where you want to go. In another presentation, we would say that we want to have a 1, 3, 5, and 10-year runway plan of where we want to go with our businesses. I invite you to do that, but that's not part of this presentation. Another issue that we always want to take care of, especially as we're transitioning from solos, is the tax implications of running a partnership, or running the limited liability partnership, and then running your company as a professional corporation. And I'm glad I said the word company. I'm going to give you a little lesson that I learned from a colleague who is a partner at a big law firm. And we were at a cocktail party, and he and I we're social friends. We're both fly fishermen, and his wife was there. And I was talking to my friend about my idealism at the law. This was quite a bit ago. And And the Mrs. chimed in and she says, Louis, being a lawyer is a business. It's about money. And true, we provide a service, but running a business is about money. We like to go on our vacations. We only need to pay rent. We need to pay overhead and payroll. So this is a vehicle that we can use to protect that asset. Oh, I also want to say that in the handouts, I do provide a rough checklist of some of the things that you want to perform and do to create an entity. All right, now the options. Most of us, or many of us, are sole proprietors. That's our solos. Another option that we have is a general partnership. I don't like that, but there are some successful law firms with more than 5 lawyers that are run as general partnerships. Then we have, certainly in California, we have the limited liability partnerships. I don't know why we always mention this when we say no LLCs, because attorneys can't provide, LLCs are not available. LLC entities are not available for certain service providers, engineers, mechanical engineers, accountants, us, architects. And then we have a professional corporation, which leads us to the consideration of whether or not we need an entity. I believe that really ties into the plan of where we want to take our businesses. So some of the considerations that we want to do as we consider is, what are the long-term plans? For instance, let's say as an example that you are collaborating with other attorneys, which many of us do. And sometimes that collaboration gets a little bit close, just simply because you work well together and things are going successfully. So a consideration would be, well, if I want to work with this other attorney as more than just an ad hoc relationship, how do we want to do this relationship? And depending on a lot of different factors, but whatever you decide with the other person or persons, is, do you want to run it as a limited liability partnership or as a corporation? And a little bit later, we'll talk about some of the considerations of the corporation. For smaller law firms, it's pretty straightforward. It's still, we need to consider that. And part of that consideration is how you govern the actual entity. And that means how, basically, I'm a little bit rough on this, is how are you going to divide the profits? Really, that's what it comes down to when it comes down to a business. How are you going to divide the profits? It's a little bit easier sometimes as to how you divide the production and the supervision of the actual law firm. It takes a lot of work to work that out, whether it's in an operating agreement or the bylaws, but still I prefer some sort of an agreement between even shareholders as to who's going to be the general partner, what their duties are going to be, and who's going to actually be supervising or doing the bulk of the production of the now concern. I think, yeah, right there. So I have those two bullet points in red. That is super important. In my, what I love to do in businesses, I like to make businesses and I like to take them apart. And one of the considerations that causes a lot of friction is, one, the profits, but then what are the impacts of the money coming in on the people, the shareholders, or the partners. And I always strongly recommend that you consult with a tax attorney, or I'm sorry, a CPA or a tax attorney, because at a certain level it becomes very important as to how you operate your business, what elections you take. Those are really important, especially if you start making money, and really that is the goal of running a business. And you know, I don't mean to sound like a gunfighter that we're doing this for money, because I very rarely run across attorneys at our level that are really just doing it to make the $500,000 partner salary. A lot of us really do want to help people and do the right thing, but you guys already heard about what I'm about when we're running our businesses.
I was going to ask you about the risk bullet point, but I think you're getting there in terms of moving from a sole proprietorship and evaluating whether or not you should be a corporation or something else. I think you're probably talking about that. You know, it has to do with if you want to grow or you're having employees and you want to limit liability. Is that what I'm seeing coming up? Okay.
Yes.
All right.
So, well, that's really interesting. I can really shortcut the
I'm
lot.
obviously very interested for personal
Okay.
reasons.
So let's shortcut that, because that is a big and huge important point in running a law business. Notice I didn't say a law practice. That's different. You know, that's law practice is when we're actually suing stuff, but when a law business is when we're administrating our law practice to make money. So let's talk about risk. We all know, let me skip ahead. I've got a slide here. Let's see if I can.
Use the arrows.
Oh, okay.
That might be easier.
Where is it right here?
I didn't mean to get you out of order.
No, that's okay. I don't mind. If the audience doesn't mind, I'm perfectly happy to skip about. If you guys have something that's more important, I don't know if you have the outline, I'm happy to skip that. All right. This is close enough. What it comes down to is if Terry and I form a partnership, we only have, if Terry does malpractice in her employment law, in our business and employment law firm, I will be shielded from her malpractice if I didn't participate in it. But she is not, just because we're in an entity under the corporate laws of California, she is not personally shielded from her malpractice. You know, we can cover it, part of what we talk about here is we can cover it with nice, solid insurance. And the other way around, I am only personally shielded from her malpractice, and vice versa. But we are not, as attorneys, allowed to be personally protected from liability for malpractice. And my understanding is most of the time when we get sued is for malpractice. You know, there's other things, you know, more in her realm, but that's the big consideration of forming an entity. Is I think most of us know it, but sometimes we miss that. Okay, so now I'm going to go back, try to get into. Here we go. Okay, so we spoke about that we could limit our liability for no-fault liabilities, which means what I just spoke about is the other partner's malpractice. We have a hard time shielding ourselves personally from our creditors, which is not a big thing. The other thing is that entities, when we're having staff, we're going up to the 5-employee firm, is that other businesses can be protected for some, but not all, of the liabilities that might incur from an employee's malfeasance, but we can't. Obviously, because we all know about respondent superior, we're going to get sued for things that our partners or our employees do, like for instance, where you have the harassment of employees and sexual harassment and age discrimination and those kind of things. But there is insurance that can be purchased for the firm to help protect. I'll start moving along a little bit. And if any of you have questions, please bring them up, and I'll know how to tailor the presentation. All right.
So I have a question for you.
Of course.
Okay, so if you are a sole proprietor and you've got your malpractice insurance, maybe you have $1 million or something like that in protection, you've committed malpractice, the claim that comes against you is in excess of that. You're a sole proprietor. So does that mean your personal assets are on the line for the recovery above the amount of your policy?
Yes, and that, I was going to hit that somewhere,
Oh, okay.
and well, sometimes I miss that.
And you better hope to make a policy limit demand, and if the carrier doesn't accept it, and it's a policy limit tender, then you could then sue your carrier for not accepting that for bad faith. So actually, you probably want them just to make a demand.
Well, there's a better way to cover it. Remember, my approach is we're here to make money. We're not here to litigate on our behalves. And that's the way that I approach my business, is my clients are here to do their business, not to be supporting their attorney in his vacation to Mexico. The point, so this is a huge pet peeve of mine with regard to insurance carriers. Have your net worth evaluated. Your CPA probably knows what your net worth is. Here in California, we're all worth, well, at least those of us that own property are worth at least $1 million, because most homes in the Bay Area are worth at least $1 million. And if you only have insurance for, $500,000, they're going to come after you. And so please, if you take nothing else away from this presentation, is have your insurance agent evaluate that the coverage that you have will cover a liability that might come in. That's a huge peeve, I'm sure you can tell. It happens to me, my clients all the time. All right.
So but would you be better served in that case to become a professional corporation and then just to have the assets of your law firm available for that deficiency?
But remember, for us, for attorneys, specifically with liabilities or debts to creditors and malpractice, if you're, well, here's a 2-edged sword, 3-edged sword. If we get sued for malpractice, even though we're shareholders in our professional corporation law firm, and the lawsuit is for more than the assets in the corporation, they're going to come after the shareholders. The same thing with creditors. If they say they foreclose on your law firm for $10 million and you only have $8 million in assets that you can cover, they're going to come after the shareholders for that excess $2 million. All right? All right.
So does that mean the Tom Ferrari situation, if there's not enough to pay the people that are going after them, all those partners in the law firm could be responsible?
So I'd be happy to talk about that. That's a little bit above my pay grade for this presentation. Yeah. Although I have read about that.
So it doesn't matter then, it feels like that if you're forming a corporation to stop someone from taking your personal assets, they still can.
No, because after this talk, you're going to be talking to your insurance to make sure that after you form your professional corporation, and let's say that you have $1 million in assets, and you get sued for $1.5 million or you have a liability of $1.5 million. Well, your insurance carrier is going to have $2 million in coverage for you. So let's talk about that. When I counsel my attorney clients when we're going to form an entity, I mean, we're a pretty sophisticated lot, and we know why we're doing this. Basically, why we're doing this is for marketing and to be able to have a partnership or a shareholder to work with another attorney on more or less equal terms. I believe that the biggest advantage to being able to have, instead of the law offices of Louis Montes, you have, Louis, Dewey, and whatever. So you can market to a different type of client. I know that I have lost 2 clients because of the size of my firm and because it's the law offices of Louis Montes instead of, Montes, and Montes. And it has happened a couple of times to me in startups where we take them to where they get to VC funding level. And now the VC guys are calling the shots, and they want to take them over to the peninsula, and they take them over there, and rightfully so, because the law offices of Louis and Montes are not going to be able to provide the services that they need right now. And I don't think it's okay, because I lose out on a lot of business and prestige and the clients and that kind of thing. But it happens. And I believe that you can leverage having your entity for your marketing. That's really an important part. And protecting yourself from the malpractice from your partners, or shareholders, partners and or shareholders, if you're going to be operating your law practice in that way. I see a lot of curious faces out there. Questions?
So I think the most important is the taxes, right, rather than the liability. Liability is very well reliable. Doesn't matter what this entity structure is. You only have to, because it's a business, you have to see how you can save taxes.
See, I thought about liability. If I had, because of employees, I don't want them to come after me personally, even though, I may be a sole proprietor. So, but I was thinking, maybe I'll just get EPLI insurance, employee insurance. I think of it as from the liability standpoint, because I don't like to think about taxes.
So Anita's point is well taken. Taxes is a huge part of our business. Even at my humble level, taxes are a huge consideration for my operation. But I want to ask you something about the EPO insurance.
EPLI, and I don't remember what it stands for, but it's the Employee Protection Liability Insurance.
Okay, so let's talk about that since we're talking about liability here. All the horror stories about the asshole boss, I think you said?
Yes.
Or where you have a supervisor that is being, I don't deal in that area, but sexual harassment, bullying, all that kind of stuff. You can have insurance for your company to cover this guy, my asshole shareholder in my firm, who I can't tell what to do or fire, and he's bullying somebody, and you get sued, well, if you have this EPO insurance,
Yeah.
which is, it's very expensive, but if you're running a firm more than 5 attorneys, you can probably afford it. It's very expensive, but it will cover your firm for that kind of a claim, whereas your errors and omissions insurance will not. And it's something to be considered. Look, we're attorneys, we talk about this kind of stuff. It's something to be considered if you're in that situation. All right, let's see. How am I doing for time, Anina?
15 minutes.
15 minutes. Okay, well, I'm going to hit some good stuff. Okay, so let's talk about taxes. For a smaller corporation, law firm, you want, I recommend almost universally, in fact, I've never done an S-election corporation for attorneys. And I will say this is not a large part of my practice of making corporations and entities for attorneys, because most of us attorneys are do-it-yourself and they get it done. And I coach a little bit on some of the pitfalls, but the C-election treats your corporation as a partnership where the distributions go to the partner and, I'm sorry, the shareholder, and he or she bears their own taxes. It's a little bit simpler than the S-election, and I'm not even going to talk about what happens there because, number one, I'm not really qualified to it, and I'll confuse myself more than I would want to. But if you look right here at number 4, it is very highly, strongly recommended that us attorneys, when we're seeking these elections and tax planning, that we consult with experienced CPAs, or I prefer CPAs because generally my experience is that they're more in tune with the actual reporting and managing of taxes as opposed to a tax attorney who is generally, I think, trying to defend you against some sort of mistake that the IRS has made in your taxes. All right. We're going to stick. We're going to skip the minimizing the double tax with an S election. Let's skip that. This is what is the most popular. The professional corporation. This is really popular with attorneys, and but for us, despite that it is more popular, it takes more effort for attorneys to govern this, because not only do we have corporate law and the formalities of governing the entity under California corporate law, we also have reporting that we have to make sure that we do on a yearly basis with the state bar. I think it's in your, if we fail to report our partnership, our corporation to the state bar on a yearly basis, we can be, I think, it's in here so you can read it. We get a certain amount of time, which is very short. It's a matter of days. I'm sorry?
That was a year.
No, you do not get a year. You cannot go the whole year. Here's the it's 30 or 60 days. It's in the handout, if you're considering that. You have to do it on time. Okay? There is, it's like missing a notice of appeal. Don't, because your corporation gets suspended from practicing law, which means you cannot practice law. You cannot miss that, okay? That's just the way it is. we get suspended from that. Let's see.
State Bar doesn't have to approve then your corporation, you just have to notify them if you are forming an entity. Am I understanding that right?
No, I think it's.
You have to fill out a form every year, pay your $75, and,
So you presently do that?
yeah, I'm a professional corporation.
Okay. And so do you remember what the length of time that you have to?
I don't.
Yeah,
I mean,
I believe, I would bet you a half a cup of coffee that it's 60 days
it's something like that.
past the deadline.
Yeah, I think it's
But they
something
still
like,
have
but,
to approve it and,
Yeah.
no.
Okay, so let me tell you how the process works.
They don't really have to prove it. I mean,
Their name.
It's like your statement of information with the bar.
I'm sorry?
You know how you file a statement of information on the corporation legally?
that's a little different.
Yeah, it's a little
That's
different.
what the Secretary of State, I'm just saying, this is with the bar.
It's called the law corporation section of the bar.
All right, so I'm going to try and find the way
It's
that
in the
you
material.
start. How much time do I have, Anina? 10 minutes, okay. I'm going to do this because this is important.
Well, it says actually, I found it for you. It says a law corporation must annually renew a certificate, and it must complete an annual renewal fee, or it will be suspended for the practice of law. It may be reinstated upon submission within 1 year of the renewal fee and any penalty. If the suspension lasts more than 1 year, the registration of the law corporation may be involuntarily terminated.
Thank you for helping with my corporation. So yeah, it still doesn't answer the amount of time that you have to be late. Just don't be late.
You do get charged extra if you're late. Instead of $75, it's like $180 or something like that.
That is a de minimis consideration. Okay. All right, so this is important. A law corporation must pay its nope, I'm sorry, I skipped that. This is important, it's highlighted. If an attorney is not married to an attorney, the couple's living trust has to make arrangements that enables the trust to be able to, that only the attorney can vote its shares, and also the trust has to state that the shares that would otherwise go to the non-attorney spouse can only be purchased by an attorney. The importance of that is that your non-attorney spouse cannot control or govern the law business as you would if you had a construction company. Your now spouse, because you're not around anymore, can come in and manage the business. That's, I think we all know, but it can't practice without a law license. So that is a big thing that one needs to have. Go ahead.
That's included in the corporation's bylaws.
If you put it in there.
Well, it should be incorporated in the bylaws.
Mm-hmm.
In fact, I think the state bar requires that.
All right, we're going to skip that one because that one's not, I think I touched on the concerns about a general partnership, is that in a general partnership, you're just liable. Everybody is jointly and separately liable for liabilities. It's malpractice debts. And the other thing with a partnership that I find a little bit disconcerting is that if we're in a general partnership, she can bind the partnership to obligations that I might otherwise not approve to if we had to go through a shareholder meeting to approve whatever it is that I didn't want her to bind the corporation and thus me too. Let's see. I would encourage you to read this one on your own there. Partner liability. Okay, as you move up the food chain for like the limited liability considerations, as we were mentioning, the annual filings, And the way that you distribute earnings through the LLP is also controlled, but not onerously, but you do have to adhere to the guidelines that the IRS puts out to avoid penalties, basically. Let's see. Something that was important here on how to form a all right, so I'm just going to skip to the essential documents. I think that this is important. You must follow the procedures, what we call the corporate formalities, so that you don't give the opportunity to third parties that are trying to sue you or the entity from piercing the corporate veil. I had a story to give you to that, but I'm not going to because of my time limitation there. But you must follow the bylaws. When you form these entities where you really want to put your effort and thought and resources is to the drafting your partnership agreement, if you're in a partnership, to drafting your bylaws and either a shareholder agreement or a partnership agreement as to how you're actually going to manage the firm itself, and really most importantly is how you're going to distribute the earnings so that everybody that's going to get earnings, meaning either shareholders or partners, know what's coming and they don't get disappointed when I'm going to say an arbitrary or even a decision about money distribution comes up, because as we all know, it's people fight about money, and we're all expecting to make more than the next person. So that really needs to be clarified in those agreements. There's a disclaimer. None of what I told you is true. And go on the website. But really, if you're interested in this, I encourage you to go to the handouts that are online. I tried to include the checklist that I use that makes it pretty clear to me how we go about creating these entities for attorneys. And if you have any questions, feel free to give me a call. I'm happy. Anybody here, I'm happy to answer some questions just to help you out. And with that, I thank you for being here. Happy Thanksgiving, and I'm happy to answer questions if you have any for a few minutes.
Does anyone have questions? I want to thank you all for coming, and to remind you to please fill out the evaluation forms. Your certificates will be online December. Start looking for those, and please come to our party. You can register on the CCCBA site for the solo section, and thank you for coming.